Howdy, this is the second of 3 videos on legal concepts and terminology. And so we talked about in the last video jurisdiction, we talked about the differences between state and federal laws, we talked about district courts, appellate courts, and Supreme Courts, both at state and federal. And now if my slide advances, we will talk about venue. Venue means geographic. Geographic is this. Don't confuse it with jurisdiction. Jurisdiction is about the power to regulate. Venue is where a case will be heard, and it's a geographical term. So for instance, when I did contracts as a contracts lawyer, I would always put a clause in that says you are bound by the laws, this contract is interpreted under the laws of the state of Texas with venue in Harris County, Houston, or Travis County, or whatever county. So venue is the locale where the case can be heard, and there are rules about this. That's why, for instance, in criminal cases, if they believe there's too much prejudice, they will file a motion to change the venue, because the venue typically, almost always, 99.9% of the time, goes to where the crime occurred. So if the crime occurred in Harris County, it would be held in Harris County courts. But in criminal cases, you will get a change of venue. Your venue laws is if you set venue, or your rules rather, it's pretty much a done deal. You can argue venue in civil cases, but it's pretty much set by the law. So here's the thing, when you talk about venue, sometimes people think venue and jurisdiction are synonymous. They are not. Jurisdiction is the power to regulate among whatever boundaries, and venue is a geographical term about where the case will be heard. Now we're going to do an entire chapter on standing, but I want to talk about standing because you have to have standing to bring a lawsuit, and many people do not realize this is one of our constitutional rights, not in the Bill of Rights, but in Article 3. And again, the elements of standing are established, wrong word, established by the Supreme Court of the United States. When we talk about this in Chapter 2, it's always a surprise that one of the cases that established the elements of standing was actually a death row case. Now here's where the legal process is separate than what the case is being heard. That is the definitive case on what constitutes standing. So, standing is the right to bring a lawsuit. You suffered an injury. The injury must be traceable to the defendant's behavior, and it can be redressed. So let me give you an extreme example. I get killed in a car accident. Did I suffer an injury? Yes. Can it be traced to someone's bad behavior, the defendant? Yes. But do I have standing to sue? No, because the injury cannot be redressed. In other words, it can't bring me back to life. My estate would sue. My family would sue. Okay? What happens in cybersecurity cases is many times there is an injury suffered. You've had your data breached, you've had your identity stolen, something like that, but it can't be traced to the defendant's behavior because you can't provide the clear causal link that that's why your identity was stolen. So standing turns out to be a big barrier to overcome in these cases, and that's why we have an entire textbook chapter on standing, Chapter 2. Now, the other thing is we must have a case or controversy. Courts do not give advisory opinions. Don't go to a court and say, I want to do a what if. What if I did this? What would happen? Sometimes people think the Supreme Court, the Alaska Supreme Court nominee, the Senate, then they're grandstanding. Well, how would you rule if Roe v. Wade came before you today? By judicial ethics, they can't answer that question because courts cannot give advisory opinions or what if, what if, what if. It has to be an actual dispute between parties. It has to be an actual conflict and not moot. And by moot, it means somehow it got solved and the problem went away. Okay, now we're going to talk about evidence standards. In a civil case, the preponderance of the evidence, think of it as 51-49, more likely than not. Okay? In a criminal case, we've heard these terms beyond a reasonable doubt. And that's why when a person is found not guilty, it doesn't necessarily mean they're innocent of the crime. Excuse me. What it means is they could not prove the case beyond a reasonable doubt. It's a very high threshold. So in some cases, such as O.J. Simpson, he was found not guilty of the murders in criminal court, but in civil court, he was found liable for the deaths of 2 people. and forced into a financial settlement because the evidence standards are different in civil and criminal courts. Excuse me. You will also hear a term, clear and convincing evidence. This is a higher standard than preponderance, lower standard than beyond a reasonable doubt. This is typically clear and convincing evidence is used in the legal process. You'll get to a process and the judge cannot entertain a motion until there's clear and convincing evidence, which is substantially more likely than not to be true. But there's no numbers assigned to this. You just kind of have to wing it. Don't confuse in criminal. Beyond a reasonable doubt is when you get to court. To get a Fourth Amendment search warrant, which we will talk about, because this has become a very prevalent issue on what electronic data can be accessed with or without requiring a Fourth Amendment search warrant. You talk about probable cause. That's not an evidence standard per se. Probable cause is a requirement of the Fourth Amendment, and we're going to have a chapter on this, so don't worry about it. And it says, basically, I have reasonable belief and reasonable suspicion that there's credible evidence, and as a law officer, I am willing to sign, affirm an oath or affirmation of such under threat of perjury to have a judge grant the warrant. Now, we're going to talk about common law causes of action. This is what's come out of court cases, contract breach, breach of implied warranty, and the like. Contract breach is just that. We have a contract breach that's governed typically by common law, how the courts have ruled what constitutes a contract or not. If I have a document labeled, this is a contract, that does not make it a contract. If I have a document labeled, this is not a contract, that does not negate the fact it's a contract. A contract is based on a transaction between two parties where there is mutual consideration, which means party A and party B, each party has to gain something. So, for instance, if I said to my TA, if you take my class and you get an A, I'm going to give you $100. And then he takes my class and he gets an A and I don't give him the $100, and he can't claim contract breach because there was no consideration. Now, I broke a promise and I was a jerk, but it does not constitute the elements of a contract. So many cases first start with, does a contract exist? Does a valid contract exist? And then you hear all kinds of people who Google stuff. You can't have oral contracts. You can't have contracts only signed by one party. There's all these nuances of contract law, which we won't go into. Breach of implied warranty means just that. There was not an express warranty. There was an implied warranty. You had control of my personal data, and that responsibility implies that you have a warranty to protect that data, and you breached that. This is where we've taken something from physical assets now, and we're trying to use it in the electronic world. Negligence is a tort. It's a reasonable person standard. It means someone did not do what a reasonable person would did. They were negligent. What you want to understand, and sometimes parties are found grossly negligent, and that affects the damages. They can get punitive damages. What you also want to consider in all these is each of these have their own way of establishing damages. So contract breach, for instance, the damages in a contract breach is to put the party back to how it was before the contract went into place. But under negligence, there can be punitive damages. There can't be punitive damages in contract breach. So a good lawyer, first of all, when they file a claim, will throw as many of these as they can at the defendant, but they will try to pick the one that's going to maximize the damages. So sometimes something that's clearly a contract breach, they will sue under negligence because they can get more money. Unjust enrichment, here's an example. My stockbroker, I'm a stockbroker, I take $100,000 out of your account. You sue me for, and then you notice it's gone, so I give it back to you, and I even pay statutory interest, so I give you $102,000. But in the time I took that $100,000, I invested it, and I made $200,000. So you get your $102,000 back, and I've got $98,000. I was unjustly enriched. And so this is a cause of action in Texas. Money gets put into account wrong. People take control of something. You know, and keep in mind, these are civil causes of action. You may still have criminal action, but this is civil. Fraud, slander, invasion of privacy, we'll see all these come into play. Now, I want you to take some time, and there may be a discussion on this, but here's where we're going to build our analysis framework. Begin to think about how cyber events can be complicated because of these, what we've talked about, jurisdiction, standing, and moot case. And that's what this course is all about. is now that we have the basics, that we can confidently use the terms jurisdiction and know the difference of venue, and after Chapter 2, understand standing. And then we will see, okay, this is how it works in the physical world. It doesn't work that way in the electronic world. Either how does it work, or what laws are needed, or what laws are there. Thank you for staying with me. This is the end of the second video of 3.